Hello everyone, you are welcome on this course, that is Understanding Competition Law, Theory and Practice. Myself, Dr. Mayank Pratap, Assistant Professor Faculty of Law from Banaras Hindu University. So we will deal with today's lecture, that is lecture number 4 of this particular week 1. And today we'll discuss with the nature of competition law. And in this particular lecture, we will discuss the competition law's nature with the objective to discuss the nature of competition law, to discuss the nature of CCI, that is Competition Commission of India, and to discuss the enforcement mechanism and tools which is provided under the Competition Act with the jurisdiction with CCI, and to understand the unique feature or characteristics of the Competition Act. So, to begin with this nature of competition law, let's have a recap with previous lecture, that is lecture 3. So, if you remember with lecture 3, what we have discussed, the competition law, that is why competition law is important, what are the justification behind adoption of competition law, and what are the necessity for the purpose of competition law. So, that what we have discussed in last lecture, that competition law, which is also known as an antitrust law, is actually the body or rules or set of rules or the regulation which is designed to promote the promotion and some competition policy which refer to the specific law regulation that governs competition in particular jurisdiction. So there are two terms which is important, that is competition law and competition policy. And with reference to competition law, what we have discussed in last lecture, the competition law, the necessity of competition law is for the purpose of to prohibit or restrict the anti-competitive practices, and competition law, that is competition policy, is referred to broader set of principle, guidelines and objective that guide the development and enforcement of competition laws. Competition policies, on the other hand, provide the framework for competition law, outlines the objective and guideline for promotion of competition and prohibition of anti-competitive practices such as merger, acquisition regulation and abuse of dominance. So, in summary, what we can say, the competition law is necessary for the purpose of to promote the competition, to prohibit the anti-competitive practices, to prohibit the abuse of dominant position and to regulate the combination which includes merger and acquisition. So, with this, if we begin with this today's lecture, which is about the nature of competition law. What is the nature of competition law? In fact, if you discuss the nature of any particular subject, with reference to its nature, its general meaning, what is the attribute or what are the attributes or what is the characteristics of the particular subject. In perspective of law, we generally deal with the nature in reference to civil law, criminal law, substantive law, procedural law, but competition law is a very unique law. So, if we discuss the nature of competition law, first we have to deal with its attributes, its characteristics and what are the unique feature which is embodied in the competition law. So, we can discuss the actual nature of competition law. So, with reference, if you think the competition law is basically the codification of rules which is designed to promote the sustain the competition in the market. Across the globe, that means at a global gesture, if you see, these laws are prevalent to active enforcement, advocacy function, and today's more than 125, approximately 129 countries are which have adopted the competition law regime and competition law enforcement agencies. Though the practice of competition law varies from jurisdiction to jurisdiction, but to substance these law is primarily the same, that means the basic object and the aim of the competition law is same throughout the globe. The word over is prohibit the practice and they restrict the anti-competitive practices. It is for the purpose of to promote competition, to fair competition and to advocacy of the competitive advocacy. And of course, business have certain obligations under competition law, and it is important to understand to abide the rules. So, the primary goal of competition law is to ensure the business compete with each other on merit rather than through unfair or disruptive means. Meaning of unfair, what we have already discussed in lecture number 2 if you discuss. So, the Competition Act 2002 is a regulatory regulation and they govern business practices in India. So if you see the term regulatory regulation, that means it is basically an act which is for the purpose to regulate the competition in the market, because we have already discussed the competition is a generic or general term, which means in the market sense, if you see, where multiple firms which they rivals to each other for strive the common goal to achieve the market. That means basically they offer the product and services to the customer, and with the objective to attract the customer and for spreading its business. So at that field they may adopt some competitive, that is fair competitive formula, and sometimes the unfair competitive formula. So in this point, competition law is important to regulate the competition, which must be gone with fair competition and the rule of fair competition provided by the equal level field. So that with this you can say the nature of the competition law is regulatory in manner. If you see the basic objective of competition law, why we are saying that is a regulation or it is a regulatory law, because it is certainly to promote the competition, if you see the key objective, and to prevent the anti-competitive practices and to protect the consumer interest. That means actually it is a regulation which is for the purpose to encourage the competition. It encourages the innovative efficiency by reducing the price, which is ultimately beneficiary to the consumer. And on the other hand, the other objective or key element of this is to prevent anti-competitive practices. Actually, it is a regulation which prohibit agreement, merger, acquisition that could lead to creation of monopoly and abuse of dominant structure. And again, the ultimate object of the competition law, which is the main attribute of the competition law, is that is for the purpose of to protect the consumer interest. So these are only the safeguard for the purpose of consumer to prevent them from unfair business practices such as price fixing, cart laying, bid rigging, and any type of deceptive advertisement. So now the question is how the act regulate the business practice. If it is a regulatory practice or regulatory regulation, what are the tools by which it regulate the function or it regulate the competition attributes? So if you see the objective of the competition law, there are three main wings. It is for the purpose and to regulate the anti-competitive practices. That means this is an act which prohibit agreement that limit, control or attempt control production, distribution, sale or price of goods or services. And the second thing, this abuse of dominant position. This is the act which prohibits enterprises from abusing their dominant position. And the third one is merger and acquisition. So this is an act which is for the purpose to regulate the combination, and their combination means merger, acquisition or any type of takeover of the companies or one enterprises to another enterprises. That means which include the merger, amalgamation, acquisition or any type of the constructive activities of the company to ensure that they do not have adversely affect the competition. So how they regulate, this is a main purpose. There are some tools, but there is actually an enforcing body. For the purpose of regulation or execution, there must be a power, and the power lies in this regulation with the enforcement body, and that enforcement body is Competition Commission of India. If you see the preamble of Competition Act 2002, which lays down that it is an act with aim to provide for a commission to prevent practices having adverse effect on competition, to promote and sustain the competition in market, to ensure freedom of trade carried on by other participants in markets in India. Accordingly, the Competition Commission of India, that means CCI, has been formed to ensure that the Indian market complies with the objective of this act, and the central government as well as CCI has been granted the power to make various rules and regulation in order to further the purpose of act. And what is the enforcement mechanism? That means enforcement body is CCI, but what power has CCI? Whether CCI is an investigating agency or which type of the power or which mechanism they deal with the to execute its power and function. And so if you see the enforcement mechanism, they actually investigate the matter suo motu on complaint or the complaint by anyone. So with the investigation mechanism, regulatory bodies investigate suspected anti-competitive practices and gather evidence. Fines and penalty. Businesses found guilty of anti-competitive practices may face significant fine, penalty or any criminal prosecution. And third one is by reviewing the merger or reviewing the any type of combination. That means regulatory bodies reviewed proposed merger and acquisition to ensure that they do not substantially lessen competition. So with these, if you go with some judicial aspect about the constitutionality, and particularly the constitutionality was challenged regarding to CCI about the jurisdiction and power regarding issuing on any order, particularly in the manner under section 27, how they impose the penalty. So in this way, the Supreme Court in the case of Brahmadatta versus Union of India held that Competition Commission of India is mainly a regulatory, not judicial body. So see what we are discussing here, the nature of competition law, and we started to discuss the nature, and the first and prior nature is it is a regulatory body. So if you see the case that is dealt by the Honorable Supreme Court in Brahmadatta Union of India, Supreme Court clearly said this is not a judicial body, that is about the CCI, but it is a regulatory body because it is constituted under the act, which is a regulatory act. And the petitioner Brahmadatta, a practicing advocate, challenged the constitutional validity of Rule 3 of Competition Commission of India of Rule 2003 on the ground that though the Competition Commission of India was largely a judicial body, the power to select and appoint its member was conferred with the central government. So it was contended that the rule in question was contrary to the doctrine of separation of power and was liable to struck down. The court observed if the expert body is created, then it might be appropriate to create two separate bodies, one being the advisory and regulatory and other being it adjudicatory. So with these line, with the amendment, one more agencies with the CCI, that is appellate body, comes in the picture. So if you begin with nature of competition law, what we can see, primarily it is a regulation to regulate the competition in India. So that is a regulatory function. So competition law, if you see the regulatory framework, it is a regulatory framework designed to promote fair competition and prevent anti-competitive practices in the marketplace. So as a regulatory framework, competition law sets rule and guideline that businesses must follow to ensure a level playing field and protect consumer interest. What are the key characteristics of a regulatory competition law? Because if this is a regulatory competition law, what are the attributes on which basis we can see it is a regulatory? So if you see the regulatory function, what we have, the rule-based approach. The approach of Competition Commission of India, which is constituted under the Competition Act 2002, is basically deal the cases with rule-based approach. That means competition law establishes a set of rules such as prohibition on price fixing, bid rigging and abuse of dominant position. It is ex ante regulation. That means competition law regulates business conduct before it occurs, though like the merger review, licensing requirement and other types of prior approval. It is regulation which regulate the ex post facto enforcement. Competition law is also provided ex post enforcement where regulatory bodies investigate and penalize businesses for anti-competitive conduct. And public enforcement, competition law is enforced by public agencies such as the CCI, which have the power to investigate, penalize and impose remedies. So what are the regulatory tool? Now another question, if it is a regulation and it is with the nature of regulatory framework, what are the regulatory tool which has been used in the competition law with the CCI. So that is merger review, investigation and fine and penalty. Merger review means regulatory body reviews proposed merger and acquisition so that they do not substantially lesser competition. And the second one is investigation. Regulatory bodies investigate suspended any anti-competitive practices and fine and penalties. Business found guilty of anti-competitive practices may face significant fine, penalty or even criminal prosecution. Again, one more question about the nature of competition law, because what we have earlier discussed in introductory session that it is basically a branch of economic law. Now the question is whether it is economic law, that means it is not a social law, or sometimes the question is whether it is a social law or economic law. No doubt primarily it is a economic law which is deal with the market competitive environment, competition and economic wing. But on the same hand, if you see the attributes of this particular act, that is Competition Act 2002, Competition Law of India is a complex and multifaceted field that can be characterized as both social and economic law. The social law aspects and economic law aspects both included in this, that means as per their unique characteristics. If you go with the social aspect, if you try to find out what are the social aspect or impact with the competition law, you will see that the prime and major function of this act is to protect the consumer welfare or protection of consumer welfare and promotion of consumer welfare. It is again to promote fair market practices and to encourage innovation and choice. So is this function, if you see this function, the social law aspect of the competition law is competition law basically to provide benefit to the consumer, that is it is basically with the objective to provide ultimate benefit to the consumer, that is mass at large, the public, the people, the ordinary people, for the purpose of promotion of fair market practices. It regulates the competition, that means it does not stop the competition, it does not mean it is only promote competition, rather it encourages and promote the fair competition, that means the competition which is adopted by fair means and by enforcing the fair tools, and it encourages the innovation and choice. Innovation, that is for the purpose of to reduce the price and to increase the efficiency. So innovation is important, and choice that means varieties in product and services, so that the customer or client have varieties of selection for the choices as per their choice. So in this respect, it is basically a social law, and the attribute what we are discussing here, it is a social law aspect. Again, if we try to find out the economic law perspective or economic law aspect, we can see actually it is a economic law because it deals with the market, financial market regulation, competition policies, policy that govern the economic perspective of the law. So that no doubt it is economic law or with the aspect or the element of economic law there. But if we try to find out some particular aspect or particular element or key element regarding the economic law aspect, you will find that it is to regulate or regulation for market structure. Competition law actually regulates market structure such as merger, acquisition, to prevent the concentration of market power. Again, it is to promote or promotion of economic efficiencies. Competition law aims to promote economic efficiencies by encouraging business to reduce cost, improve productivity and innovation. And again, it is for the purpose to maintaining the market stability. Competition law actually help to maintain market stability by preventing anti-competitive practices. So you can see there are both aspects which are included in the competition law, that is social law aspect and economic law aspect. So one cannot say that it is a pure economic law or only economic law, because no doubt it is an economic law, branch of economic law, but having the social law aspect. That's why we are saying that actually the nature of competition law is hybrid. Why we are saying that is a hybrid? Because it is interlinked with social aspect and economic aspect as well. There are 2-3 points by which you can understand the hybrid nature of competition law, that is the interplay between social and economic goal. Competition law actually try to balance the social goal such as protecting consumer welfare with economic goals, promoting and encourage efficiency. It is in the context of dependent application. Competition law is applied in a context-dependent manner, taking into account the specific market, industry and economic condition. And again, the nature is like the evolutionary because competition law is dynamic. It is not static. It's change as per the policies, as per the demand, as per the market, so that you can say it is not static, rather it evolve in response to the change in market, economy and society. That's why we are using the term the evolutionary nature of competition law. So in conclusion, you can say competition law is a hybrid of social and economic law, balancing goals such as protecting consumer welfare and promoting economic efficiency. But again, the question is, what is basically the nature of competition law from legal perspective? From the legal perspective, because if you see the categorization from the legal perspective, a law may be a social law, maybe that means a civil law or a criminal law, procedure law, substantive law, somehow the public law or private law, which are the categorization as per the academic interest of any law. So that if you see on this ground, competition law, which is also known as antitrust law, is a complex and multifaceted field that has a unique nature. It combines elements of public law as well as civil law, criminal law to promote competition and to prevent anti-competitive practices and to protect consumer interest. We can take some elements from every aspect, like the public law. How you can say this is a public law in nature, and why you are saying that is a nature with the public law elements. So if you see, the competition law is primarily a public law regime as it enforced by enforcement agencies which is responsible for regulating market and ensuring compliance. The primary goal is to promote competition, ensure market integrity and protect consumer welfare. It is a regulatory framework and investigation and enforcement. It is public law because there are two elements, that is regulatory framework, that is competition law is basically based to regulate the things, that is a regulatory framework that sets out rule, guideline and business to follow, and other element is investigation and enforcement. The public authorities such as Competition Commission of India investigate and prosecute the competition law violation, imposing penalties and fine. On the same hand, if you try to find out the civil law nature of competition law, the competition law also has a civil law component, as individuals and businesses can bring private lawsuits against companies that violates competition laws. Private enforcement and contractual disputes. Private enforcement, actually private parties can bring civil lawsuits against companies that engage in anti-competitive practices, seeking damages and injunction relief. Contractual disputes. The competition law issues often arise in contractual dispute between businesses which are resolved through civil litigation. So that we can see here the civil law nature of this competition law. And again, there are some elements which indicate the criminal law nature of competition law. Like in some jurisdiction, competition law violations can lead to criminal prosecution and penalties. Just criminal penalties companies or individual that engages in serious anti-competitive practices such as cartel activities can face criminal prosecution and penalties including imprisonment, and leniency programs are there. That means companies that cooperate with investigation and provide evidence of wrongdoing may receive leniency or immunity from criminal prosecution. So with this, there are some more element like economic nature, what we have already discussed with the economic nature, but some more element, if you see the economic nature, is like market regulation and economic analysis. That is economic analysis. Actually, economic analysis plays a crucial role in competition law as it helps in assess the impact of business practice on competition and consumer welfare. And the one more important thing, the international nature of competition law. Competition law is interestingly become increasingly in scope as businesses operate globally and competition law regime covers. International cooperation and global best practices are the elements. The competition authorities cooperate internationally to investigate and prosecute cross-border competition law violations, and on the other hand, global best practices are there. There is a growing trend towards adoption global best practices in competition law, with many countries converging on similar approach. So in conclusion, the nature of competition law is complex and multifaceted, combining the elements of public law, civil law, criminal law, economic theory, and international cooperation. In unique nature reflect the driver's goal and objective of competition law, including promotion of competition, preventing anti-competitive practices, and protecting the consumer welfare. So with these objective, that means where the objective of this particular act to encourage the efficiency, encourage the innovation, promotion of the competition, the fair and just competition, and to regulate the things which is anti-competitive elements like anti-competitive practices, or to regulate the merger and encourage the advocacy related to Competition Act. So with this we can see there is no a single or particular nature of competition law. Primarily, competition law is a branch of economic law and it is an economic law. Competition law, primarily the public law as per category. This is mainly deal with public law in nature, but there are unique characteristics, some characteristic with civil law, criminal law, economic law, social aspect, and also economic aspect. So in conclusion, what we can say, the nature of competition law is not static, rather it is evolutionary and complex and multifaceted, with attributes of all features of any dimensions related to the civil society. So with this, we will meet in next lecture with the topic constitutional perspective of competition law India. So thank you very much.